Technology in the Law Office. Chapter 12, Evolving Issues in Discovery. This is a pretty straightforward and simple chapter. Mainly what we deal with is the necessity of preserving electronic documents during the discovery process, and what you need to be saving even before litigation begins. After this lecture, you'll be able to explain the purpose of a litigation hold and the duty to preserve evidence, define spallation and explain its significance in discovery, describe the potential sanctions for spallation of evidence. That's a tricky word, spallation. The rise in the number of electronic documents used in society has dramatically increased the volume and scope of e-discovery. We're sending so much, instead of picking up a phone, we're sending an email. Since we have these electronic documents, they're discoverable. And emails and word processor documents may number in the thousands or more. Because these documents could be the subject of an e-discovery in a potential lawsuit, attorneys frequently advise clients on establishing retention policies. That means how long are they keeping things for? And so it's not just establishing retention policies, they need to follow their retention policies. Because it's even worse if they don't follow their own policies. And attorneys must be able to advise clients on how long to keep these documents. And that's going to vary. The new Federal Rules of Civil Procedures address three specific concerns, namely preserving electronic materials, producing electronic materials, and destruction of electronic materials. A client that is concerned about a potential lawsuit can easily destroy evidence contained in electronic files. And we want to prevent that. Once a client has a reasonable belief that litigation may arise from a dispute, so it doesn't even have to have been started, even then, a duty arises to preserve all documents related to that dispute, both paper and electronic. It has been left to the courts to determine what constitutes a reasonable belief, and different jurisdictions have come up with different outcomes. But the emerging line of cases suggests the duty to preserve information arises if the party knows or should have known of the possibility of litigation. Preservation may require placing placing a matter and all documents related to it on litigation hold. This term serves as a red flag to the company and its employees not to destroy or alter any documents related to the dispute. When litigation is actually commenced, counsel must issue a litigation hold letter to a client. And this is kind of like a form letter. Looks like this. Litigation hold letter. And you just fill in the blanks. And and once you've done that, and lawyers are required to do this. Okay? So this is an example. You can read it later, but it basically, is plug in the information for the company that you're dealing with and have everything put on hold, including emails, other electronic communication, word processing documents, spreadsheets, databases, calendars, telephone logs, so much. I mean, I've had lawyers I know who, just so that this isn't a possibility, always call me and talk to me. So there is no electronic record. And there goes some more. So continuing with the litigation hold, the record retention policy should include a litigation hold policy, and the client needs to establish a set of rules for determining which matters may result in litigation and for ensuring that documents related to those matters are not destroyed. They don't want to put too much, of course, don't want to put too much of a burden, so they don't want them receiving records for 20 years. But there should be a reasonable policy in place for what would be a reasonable amount of time for that industry. Spoliation. Courts often use the term spoliation to refer to the destruction of evidence pertaining to litigation. Spoliation can involve almost any method of destroying evidence. Spoliation can refer to the destruction of evidence other than documents, so it could be really anything. It might involve the crushing of a motor vehicle that had damage showing the cause of an accident. Can't do that. Spoliation of evidence is punishable by court-imposed sanctions against the party who destroyed the evidence. The courts are not going to look favorably on that at all. And there might be even more damages for the spoliation than there would have been if they had lost the case. Sanctions can range from ordering additional discovery to monetary penalties. The judge may even give an adverse inference instruction to the jury because they spoiled evidence. An emerging concept in the areas of preservation and e-discovery is that of proportionality. As the cost of preserving documents in e-discovery increases, the courts are becoming increasingly concerned that litigation will be available only to the wealthy, meaning only those who can afford discovery and the lengthy process of going through all those documents are going to be the only ones that can afford, not necessarily the most worthy of justice and most needing, but simply because the cost of litigation will be too expensive for the average person. Not everything that can be preserved or discovered is needed to resolve a case. What must be weighed is the cost in proportion to the benefit. And that's kind of it. So read this chapter and do the exercises. As I said, it's not the hardest chapter in the book. I'm sure you'll get through it pretty easily. Thank you and have a good day.